Good morning. Good morning. Good morning. Good morning. Hey guys, we're a little early. I don't think it's starting for about another half an hour. So get your coffee, make your breakfast, all the things. I might let's see. Okay, let me see. Okay. Good morning. Good morning. Good morning. Hi Sanders. Good morning, glass half full. Let me go over here so I can see because good morning, everybody. Okay, we're going to get into it. Last night, I actually did my day 2 update. So nothing long or lengthy. Ended up actually like just recording it because okay, good morning. I don't know what's okay, StreamYard. I don't I it's like I hate to become a cliche of StreamYard, but it's like it's not showing the full chat. So good morning. Thank you, Shay. Shay D. Okay, Shay D. Okay. Um, Thank you for making it official. Thank you to everybody who came through this morning already. Beyonce, Glorious, Blue Bear, me, Petty Patty, Mimi, Betty Williams, Butterfly, Sanders, Glass Half Full, and Mai Tai. I see you. Okay. The mess when I clicked into StreamYard, it's like starting right here, but then I had to go over to the YouTube monitor. Like to be able to see. So good morning, good morning, good morning, everybody. So I've got the live feed, but it's not starting yet. Sis looks perturbed. Like, I don't know. Sis is look, I would be feeling away if I were sitting around waiting and I had a 15-year offer and I was dumb enough to decline it and then take it to the box, as Sonia would say. And I have, when Judge Kranick said, do you understand that you could be facing up to 22 and a half years minimum? And she had the nerve to sit there and say, yes, I do. Girl, it's like we already knew something's wrong with her. You know what I'm saying? Like something is wrong with that situation because nobody in their right mind would do such a foolish thing, right? But Sarah, but Sarah, okay? Sarah is taking it to the box. They have been in jury selection all week. Today is Wednesday. Today is Hump Day Wednesday. Miss Green, bonjour. Ça va? Bonjour. Bonjour, bonjour, bonjour. The state of Florida is not playing with ma'am today. And sis is going to be sitting. I wonder if she's going to have another suit. You could not tell Sarah anything in her suit yesterday. Okay. Sarah has a blouse. She had it open. I don't know if she's got a cami on or something, but it appears that she's got several buttons open. Um, she keeps tugging at the jacket, so maybe it's a little bit ill-fitting. I'm not sure. It looks like it fits okay. Um, the difference of Sarah Boone on alcohol and the difference of Sarah Boone eating Orange County diet, baby. And it's not to body shame or anything like that. We're not doing that. We're just talking the facts. We're talking the facts. And at the end of the day, ma'am went into Orange County. They said 140 pounds. I don't know that she looks like she's much more than that, but sis has definitely filled out. Like the difference between Sarah Boone of 2020 and Sarah Boone of 2024 is very interesting. Okay. Very different, very interesting, very much prison has given her a completely different look. I mean, it definitely has sobered her up. No lie, because I'm assuming she can't get alcohol unless she's drinking toilet punch. But at the end of the day, she did mention that she takes Lipitor and Prilosec. Does she take Prilosec? She takes Lipitor. So for The Lipitor would be for cholesterol. And I forgot what else she was saying. I felt like it was something like Prilosec. She disclosed to the judge on day one. Sober Sarah is she looks less crackish. Thank you, exactly, Erica. Thank you so much for summing it up in that way. That is your girl couldn't have said it better. Okay. The unsober Sarah was giving lean, very lean. Okay. I feel like she's maybe 5'4" according to the documents. Um, was she about the same height as George? Let me look. Let me look. You know what? I don't want to mess anything up, y'all. You know what I'm saying? Like, girl, God forbid. We don't want to mess anything up. Um, I got everything. I get it all set up. Okay. Girl, I don't want to miss a ting. Okay. All right, let's go back. Let's go back to the feed on X because I love corporate Sarah. I think she's feeling like I'm not going to say she's never worn a suit before. I don't know that to be true, but all I know is that she is happy as hell wearing that suit. I feel like maybe she thinks she just wanted the experience. I don't know who wants to have this type of an experience, but I tell you what, it seems like she is enjoying this ride, and I hope she does because it's not going to be when Mr. J and Mr. Cacciatore handle business. Motions hearing at 9:30 this morning. You can watch it live on the above link. Jury selection resumes this afternoon with no live stream. So good. We're going to get a little MC Goutte. Mrs. Green, you know what I'm talking about. A little taste, a little taste, MC Goutte. Okay. MC Goo. Okay. And tomorrow, I'm assuming we're going all in. So I hope that they have a successful voir dire. Okay. It's just all the French for me. Did she say Prilosec? She said something about Lipitor, which Lipitor, I believe, is a cholesterol situation. And did I get that right? My mom would always say that. MC Goutte. MC Gou. Okay. Um, and she said something else. We'll find it. I'll find it. I'm actually scrolling down my feed on the former Twitter streets. I'm in that going down X right now. And see what's what. But yeah, they said 9:30. This was the scene that took me out. I'm sorry. It's this is the one that gets me, like Sarah in shackles. I don't look. Everybody can, like for me, see, it's still a shock, and I feel like it should always be a shock. We should never normalize the visual of seeing someone in shackles. It's disturbing, and seeing her in shackles in this way, it's just as disturbing having seen George Torres in the suitcase. So make no mistake, but seeing a person with chains, it should never really be normalized. Like it should be shocking and jarring. That is a cautionary tale right there. Okay. Not from the outfit to the slippers to the two armed sheriffs to double shackles around your waist and just that visual. And on one side of the desk, you see the professionals, you see the ladies with their handbags. People are smiling and happy. And Sarah is going back to the reality of shackles, guards, handcuffs. It's I would have taken that deal so fast and just get my mind right and get my ass up out of there. Taking this to the box, I cannot, like, it just lets you know how foolish this woman is to think that she that the state hasn't got this locked down. You know what I'm saying? The state has had years and years and years and years to handle this business, and to think that they are not ready, and Mr. Owens has come in. I mean, is one of her points, is she going to say on top, so when they try to use the ineffective assistance of counsel, and her excuse is, well, he only had 30 days. Well, you only had 9 lawyers, and it wasn't 30 days. Maybe it's been 2 months. Maybe it's not been 3 months, but it's been roughly about, I think when he came on, he literally had about 6 weeks or so to get prepared. But if he's the true crimer that he says he is, and I mean, he is a experienced professional, right? He should be good. So we're not going to question Mr. Owens. I mean, far be it from us to question ma'am's choices. Sis, if that's who sis chose, that's who sis chose, right? Um, Let me run this real quick. Let me handle these dogs briefly, and I'm going to run my commentary from last night if you missed it. Let me run this real quick and I will be back. The proceedings will be getting started shortly. It says 9:30. I'll be back in like about a few minutes. But that way you can get an idea of what is happening today if you did not get a chance to catch it. Hopefully I can get this to go. Let's go over here. But Court TV and going to be a hey guys, welcome back to my channel. It's going to be a 9:30 start. So give me a second. Let me settle and get these dogs situated, and go ahead and hit the like button for me if you would. I so appreciate that. And let me do it like this so you guys know we're just doing a rerun from we're replaying last night's commentary, okay? While I get my dogs situated. Oh, welcome back, welcome back, welcome back. Happy Tuesday. Today is day 2 of Sarah Boone in court. Again, the Florida versus Sarah Boone second degree unalive trial. So Sarah was in court today. As you can see, ma'am was feeling pretty good about herself. And it was kind of interesting. I don't know if you guys noticed kind of a little bit of her demeanor during this whole thing, but it was giving a little snark. I don't know. It was very different from the scene we saw yesterday, which I'm sure it's the same thing when they took her out of court. However, this is very much like I'm sitting at the table. I have a seat at the table. I'm with my lawyers. I have my very serious business suit. Maybe she wears her hair parted to the side typically, but I'm gonna say I don't know anything about that. But they got her some flats basically. She was taking off her jail flip-flops. Um, Y'all, it's a mess. I'm just going to say it's a mess. Anyway, Sarah is getting her day in court like she's wanted. She has a attorney, and like I said, I think she's feeling pretty damn good about herself and what she's got going on. And maybe she's feeling optimistic about her case. And look, for the amount of money that Florida is spending on this, I would hope so. So I'm just kind of going through the Sarah Boone timeline on X, because that's pretty much, if you want to keep up with what's going on, that's kind of where you're going to find it at the moment. So there were quite a few people who are live tweeting in the courthouse because, of course, as we know, the very important process of selecting a jury is at hand for the past 2 days. They need to come to a jury of six. And based on that, with potentially maybe 6 to 8 alternates or six alternates, they will have a jury to Judge Kranick's satisfaction. They have whittled it to a pool. They had 50 first session yesterday, 50 again in the afternoon. I think they had 50 this morning. I'm following a couple of people, like I said, who are. Okay, guys, I'm back. Sorry about that. So was it okay? 10 lawyers right now because the bold guy is her lawyer as well. Okay, Mr. Henderson. But let's just so we can say 10, but let's just say lead attorney wise, it's 9 because he's on the team. Because I mean, shoot, I think some of those other ladies are lawyers too. So um we don't know how many actual lawyers are on the team. I think he stated on court TV he had like 2 other attorneys to help him out. So she's got a shit load of people helping her and have helped her, period. The woman has had more help than most, and like they stated before, this is like above and beyond. So yeah, I mean, George died in February of 2020. And, I think one thing that does get missed sometimes is the fact I don't hear it mentioned enough, but maybe whatever. Everyone knows the pandemic happened. I think also, we see some of these backlogs or we see some of these cases that have taken a long time to litigate. And I think also because there was a shutdown, there was a workaround, there was a shutdown, there were so many different things going on. So, but even just in earnest, let's just say 2 years, let's just say into 2020, 2023, this should have been settled by now. Even with Auntie Rona, at the end of the day, this matter should be a done deal by now. Um, Girl, they are fighting over a rope. Um, so yeah, I mean, this has gone on way too long. But yeah, Mr. Henderson is another lawyer on the team, but James Owens is the attorney of record, and the lead attorney, if you will. Let's see if they are what's going on, if they are in the courtroom yet. It's still showing about 9 minutes. So they haven't even gone to like showing us the medallion or anything. Let's talk something else real quick. So the rumor has it is that, so let's just pivot for just a moment. Let's pivot. So let's talk a little YSL gossip because I am so not super interested in that case, but I love the YSL gossip. Okay. All right. Number one, some YSL gossip. I think we talked about it yesterday briefly, but there was some gossip about Drake putting some money up for Jeffrey. I'm not sure what that was all about, but I'll find it and see if we have some tea to talk about regarding some legal tea. Okay. That was one thing. And then another thing is Adrian Love. I don't know if she's on vacation or she was reassigned. I read something in passing that um Fonnie Willis asked Mr. Abate to go sit lead chair over at the table. So I don't know where Adrian Love is. Is she fired? Is she off the case? Is she on some sort of come to Jesus retraining? I do not know. And we're talking about YSL right now. Adrian Love was the lead prosecutor on the case, but as we know, Miss Love, who is or Ms. Love, let's say it like that. I don't know her status. Is a former juvenile judge, okay? Juvenile court judge, I guess is how you say it. And she's so unorganized. She's so unorganized. She is doing things that annoys the judge very much so. She is taking her sweet time with this case, and she has been admonished, she has been voluntold, she has been embarrassed, she has been dragged, she has been so many different things. And maybe she's on like a little bit of a break, but from what I understand, Mr. Abadi, who was over there on the Donald Trump case, and we saw him when Fonnie Willis had to testify with Nathan Wade. Oh, I dropped the link to the video I was just showing. I don't know if it was lagging or not. I came back and it looked like it started to uh, lag. It was, there was some sort of issue or whatever. So let's just save our energy for the main event coming up shortly. Anyway, I'm not really sure what's going on with that, but we're going to find out. Okay, we're going to find out. Did I just do what I said I was not going to? Okay. Girl, hold on. Where is? Okay. Oh, here it is. Girl, I lost my tab. I thought I closed out the wrong tab. I was about to just be like, look, look. I was trying so hard. Okay. So that's just, oh, and another thing. So I pulled some docs last night. So we already know. So let me talk about it, pivot to something else that we've talked about here a lot. So Jennifer Williams, the basketball wife. Look, Nesto and Sonia 2.0. Sonia. See, Jennifer Williams and her husband, Christian Walden, he has officially filed on Monday to change his name. And I mean, I guess we knew this was coming. He's been going by Gold for a minute. But since he got with Jennifer, I guess people thought they were pulling receipts, they were going to expose and basically, called him out for that really not being his name. And, it's not uncommon for people to have nom de plume or pseudonyms or whatever. At the end of the day, though, he's going by Gold, and he's legally going to change his name. And that's really no surprise. We saw after the wedding, Jennifer put on her profile Jennifer Gold. So she's had that on there, but she can say Jennifer Gold, but Gold is really not his legal name. So we're still waiting to see the actual marriage license, marriage certificate, all of those things. So anyway, we'll talk more about that at some point today. I do want to make a call to. So I was thinking, well, okay, he's filing this name change in Cobb County. And the funny thing is, so catch this. So CG, Christian Gold, Christian Walden, Jennifer's husband, whatever you want to call it, his probation is in DeKalb. He has child support issues in Cobb. He's changing his name in Cobb. They live in Atlanta, according to the document. Why are they filing all of this in Cobb County? I don't know if it's like a lawyer situation. I don't know if you're obligated to file in the city or the county where you live. It would make you think that because I mean the address information that's on the documents is Cobb County. Allegedly they live in Fulton County. So it's like between DeKalb, Cobb, and Fulton, I would imagine that's where their marriage license, marriage certificate would be. I don't know. But I mean, you can get married anywhere. You don't necessarily have to get married in your state. You just have to if a divorce is happening, you get divorced in the county of which you have residence, and each county is different. Some counties may require you to be there 45 days. Some could be 6 months. Some could say residency up to a year. It just depends on what the stipulations are in that particular municipality, jurisdiction, whatever. But interesting. So, They got married. He did his time. He got out, and boom. Anyway, that's all I have for right now, but we'll get back on that. Let me check and see what's going on. If they have turned the cameras on over there. What is like when is it? Okay, so it's 9:28. We've got a cup. You know what? I'm going to make myself a nice hot cup of coffee. I will break in from time to time. So let's kind of talk about a little bit of housekeeping. I don't know how long this could last hours. I don't really know. Um, but they're set to go back to jury selection after, and I guess finalize whatever they need to get this situation underway. At the end of the day, I might break in here and there. We'll talk a little bit here and there if something noteworthy comes up, because, that's the fun part of doing a watch party together, right? But I probably will interrupt minimally. But you never know. Depending on how this thing goes, we might, and then of course towards the end we'll wrap it up. Um, Girl, you already know this is uh I'm a dedicated court watcher too, especially ones that are of interest to me. Um I started watching that guy. Somebody recommended it to me and I looked it up and I fell down the rabbit hole on Saturday. It was like my husband literally was like, "Okay, let's go out. Like, let's go." Did we go to my father-in-law's house? I think we went to, what did we do? Oh no, that was last week. So, girl, of the rabbit hole of that particular weekend. We went somewhere though on Saturday. Um I was watching the Quentin Nixon situation. The guy who unalived the young lady, the medical assistant situation, and it's been running on court TV. Something came up the other day, and I have got to dedicate like Saturday morning. I might just, maybe we'll watch some of it on Saturday and get caught up because it has been postponed for a month. Something came up, and the judge basically continued the case until November something. I'm not sure what happened, but he's a pro se defendant, and he was questioning the boyfriend of the medical assistant. I can't think of her name right now. Um and I don't know, but it's a great time to get caught up on this because it will probably start right after Sarah Boone ends. He's the guy who's got his hair, yes, braided, maybe some sort of locks or braids, and then has it braided into French braids. Big guy. And and I started pulling some of the documents. I pulled his complaint. I pulled a lot of information, but we've just been so bogged down with other things. But it's definitely interesting. So that might be something that we have to address on the weekends to get caught up. But it's like perfect time to get caught up on that, simply because it's on break. It's on break. Something had to have dramatically happened to make the judge say, "We'll see you in a month. Okay, let's get this sorted out and we'll be back in a month." Okay. But yeah, is it Quentin Nixon? Hold on a second. Uh Ohio versus Quentin Nixon medical assistant murder trial. Um Baby, honey. Yes. Okay. That's another thing that I'm paying attention to. Um I pulled the complaint, I pulled the police report, I pulled the initial indictment. I've got all of that stuff. It's very interesting. Okay. Um, and that led me to another trial, which was Kamaya. Is it Kamaya Harrell? This guy, his last name was Cuellar. Her husband was in the military. Let me take this down. Her husband was in the military. Kamaya Hassel, that's already been settled. I think she got life in prison. She set her husband up for a unalive by her lover. Her husband was in the military, and she did him in. YouTube lady. I don't know. I don't know what the YouTube lady is. He's doing a bit better than I would have thought. He's a smart guy. Like he's not. Look, I am sure Pro Se is not a joke, right? He's handling that business, right? Anyway, um, yes, 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 yes. Oh, YT girl, why did I think YT was YouTube? Stop it. I didn't know. Girl, you got to tell me. That's why I always tell my husband, like, you got to tell me. I don't get some stuff literally goes over my head. Okay. Quentin Nixon, I don't know, maybe I think she was Caucasian, okay? She was a white girl. She was hanging out with this guy. If we're talking about the Quentin Nixon story, let's get into that. We'll talk about that like on on the side, so quote unquote like a sidebar, okay? We'll do a little sidebar Quentin Nixon catch up. And then maybe we'll watch his testimony over the weekend or something. Any of you guys who want to watch that, because like I said, it's a great time right now to get caught up. The other thing I was talking about was Kamaya Hassel. Wait, what is her name? When I tell you, I was sitting here, my printer, I had to print stuff out. I had to go all, I had to get all like, it was too many stories I was coming across that I was like, oh my God. Okay, so Quentin Nixon is on trial for the unaliving of Tony Westover. That's one thing. That's one thing I was watching. Girl, he handwrites all of his motions just like Sarah Boone. He's not writing letters though. He's not doing all that. But he's writing all of his motions on by hand. And where is the young lady? Anyway, the thing with Kamaya and the guy Cuellar, who her and Cuellar conspired to kill this young lady's husband, is that Cuellar ended up putting in a guilty plea, and he confessed on a jail call or jail visit, rather, one of those video visits to his father. It was gut-wrenchingly sad. Um, and I thought about you guys because it was giving. Um, and he dropped all the tea about what ma'am was doing, and she's got a life sentence, okay? 20 something years old. And they were married. He was in the military, providing all of the things. They had a child. They have a child. Um, she called her mother. She told her mother too, and her mother was like, "What? You did what? What did you do?" Hold on a second, guys. Okay, guys. Let's see. It's 9:37 and court is late, okay? I never knew that. Like I honestly, I'm sure if anytime I've read that, I probably said YouTube. Like I didn't even know. Now I know. Now I know. It's like using abbreviation BLK, right? Um Look up Giselle Pellico Pelliqua. Oh, I saw that. I think isn't she in France? You're talking about the lady whose husband was gaslighting her, drugging her, and using her for his fetish. Is that what you're talking about? If that's what you're talking about, I know that case. Mhm. Okay. Okay, let me see what okay, let me go over to X. All right, I'm dying right now. Okay, let's see if they're saying anything on X. It's always so exciting when the feed starts to come on. Am I the only one who gets that? Like, oh my God, it's starting. Oh my God. Am I the only one who gets excited when the feed starts? I know I'm not. I know I'm not. Um, it's not just me. Okay, latest. Let's see what's going on here. My favorite cameraman, the whole world is here. Court TV, thank you. Let's see. When will the judge rule on the battered spouse? Inside Sarah Boone courtroom, Judge Cranick is hearing other cases. The motions hearing will begin. Okay. So Joel over there at Surviving the Survivor podcast says Judge Cranick is hearing other cases. Then the motions hearing will begin. So they're probably just trying to clear, obviously, some other business. Joel messaged that 15 minutes ago. So there you go. We have it directly from someone inside the court, one of us in the court, a YouTuber, Surviving the Survivor podcast. If you guys, or Surviving the Survivor YouTube channel, Mr. Joel over there is sitting in the courtroom. Okay. And let's see. All right, let's okay. I'm trying to see what else is going on. Okay, let's go look at the let's go take a trip down X on the X streets. Okay. I just did the latest for Sarah Boone. Someone's saying, let me just make it big. My favorite cameraman in the whole wide world is here from Court TV. Okay, when will the judge rule on the battered spouse? They might talk about that today, because there is the motion in limine. I mean, every single this is just my opinion. Every single twist and turn they take to try to enter that battered woman self defense theory, it gets shot down by Mr. J. I love the professional way Judge Cranick handles criminals with such respect. He makes sure they know exactly what is going on. He doesn't show disdain at all, regardless of their charges. No, Sarah Boone has not entered yet. Judge is sentencing 3 prisoners that took plea deals on drug crimes. Okay, thank you so much, Notorious. So Judge Cranick is consistent. That's what we're hearing. He's consistently well, number one, doing his job in the manner. It's unfortunate that because people can be so nasty and maybe people have had bad experiences with the legal system, and also maybe there's just people who are fed up and don't like their jobs, that it gets to a point where you feel like you have to thank someone for doing their job. But it is very much appreciated when someone does their job well and with professionalism, and I think we've seen that consistently for Judge Cranick. I don't, you know what I mean? He's such a gentleman, as it seems, and he's very calm, which I think it's been noted up and like everybody, yeah, everybody. I think that resonates with everyone. It's insane how many requests. I am sorry, but she is a defendant on trial for murder. Be real. Um, on elevator up to the courtroom. Do you know how long motions hearing is expected to last today? Uh, Will J, as long as it takes. I stare into the depths of his eyes. On the elevator up to the courtroom, me. So this is Joel from Surviving the Survivor podcast. Basically, he was letting us know that Mr. Will J was in the elevator. So he engaged him in conversation. Do you know how long the motions hearing is expected to last today? And the prosecutor says, as long as it takes. Ooh, ooh. And then he says, I stare into the depths of his eyes. So you just gave him a blank stare of like, oh, okay, let me be quiet. Okay. It sounds like someone is going to be missing from missing the prison commissary during the trial. So I wonder maybe they'll give her a sandwich. I'm sure they give her some sort of sandwich or something. Um yeah, he's a guy from I think he's from New Jersey. This has turned into a shit show, and the real reason we're here has been forgotten. No one has forgotten. It's Re Mangalazzo. As you're saying, this has turned into a shit show, and the real reason we're here has been forgotten. Sarah Boone murdered George Torres and should be found guilty as charged. The key should be thrown away and call it a night with this clown. Okay, but you're posting on X and you're using memes. Okay, if if in fact this is a non-serious shit show, she goes, there it is, I said it. Okay, okay, ma'am. Look, I post with memes too, but at the end of the day, ma'am, you are over here contributing. Okay, don't play like you're not here too. Okay. I'll be live streaming this morning the hearing in the Sarah Boone case at 9:20. It should be weird. Come and find out with me. That's the word on the street, you guys. Surviving the Survivor podcast. Um, Joel was clearly outside, and let's see. Sarah Boone will be wearing what the blonde woman is holding. She's listed as the jury consultant for the defense. Motions hearing begin at 9:30. So here's the another part of the team. Y'all, any of you guys on that? Okay. Corporate shoes, and I'm not putting on my cute shoes until I get into the office look. We all know about that. If you know about that, put some flip flops in the chat. I'm sure there's a flip flop emoji, but girl, we all know about that. Sis is probably bringing some heels or something. And she said, I'm gonna put, these are my comfortable shoes from the car to the court. Okay. Um, Girl, Sarah Boone wanted snacks yesterday. Um, I mean, look, we don't know her medical condition. Thank you for the flip-flops, guys. Okay. How many of you guys have worn your comfortable shoes from the car to your desk? And when you get your desk, you take your good old nasty work shoes out, or you put on whatever, like you put on those cute shoes. It's either some cute shoes or work shoes, but it's the flip-flops from the car to the desk and from your desk back to the parking lot. Okay. Because girl, sometimes that walk is long. I used to have a long walk, a couple of jobs in my lifetime. Girl, it was damn near a workout with your bag, your purse, all of the things, and those damn uncomfortable ass shoes. Okay. I want to welcome everybody who's here at the moment. If you're new here, yes, we keep it cute, but we try to keep it a little funny. Okay. Okay. Judge Cranick looks different in person, according to the streets. I'm visiting my sister in Orlando, and she wants to go to the Sarah Boone trial. Do you all know? Will I need to camp out or do anything? I get us in for a day. Let me tell you something. So much going on there. Judge Cranick just entered. He's hearing a case before Sarah Boone comes in. This is a courtroom. This courtroom is set up very differently from any other courtroom I've been in. Florida versus Sarah Boone starts at 9:30. This is The Streets Are Talking. Um, Rules are extremely different. You are not allowed to bring bottled water in with you. Another big difference is it's not freezing in here. So the temperature is just right. Okay. Final pretrial motions are being heard this morning in the Sarah Boone case, with openings slated to happen on Friday. We've heard Thursday, but who knows? It's coming soon. Okay. Anybody new to this case has all of the opportunity to get caught up. Um, Hit my Sarah Boone playlist. And there's so much out here. All you have to do is search her name and you can get all the way caught up. But I do have a playlist. 1 hour ago, Kathy, who is the managing editor at Law and Crime, um, motions hearing 9:30. So we're beyond 9:30, but again, the judge is sentencing some folk who took plea deals on drug cases. So that's what it is. And ma'am is probably getting herself together, putting the finishing touches on girl, whatever it is that she's deciding to do. Okay. All right. Who is this? Always a treat to watch Franz with Julie at Court TV opening statements. Looking forward to hearing about snacking Sarah. Sarah needed some snacks yesterday. Okay. And I mean, look, some people are hypoglycemic or diabetic. I don't know that that's any of her worries. She talked about Lipitor, and I don't know what it was. I don't Prilosec is in my brain, but I could be wrong. I know definitely Lipitor she mentioned in something else, because it kind of was like, what is she talking about? But he had just asked her about her medications, and she mentioned that on Monday. Is this no, that's not it. Girl, if she tugs at that jacket one more time, um I think that, and look, for the family, it's never gonna be pleasant. So I just think that this case has gone on for so long that, and we've seen the videos so much, we're able to, I think people are less shocked by the shock and awe of the heinous the heinous crime that occurred, and according to second degree murder, the depraved heart, all of the things. So I think we've all had time to process. I'm trying to see if I can find that clip where um they are asking her about any of her medications, and she the judge is really good, but when he's going to put an end to Sarah Boone merry-go-round, like, this judge is really good, but when is he going to put, I mean, he's gonna put it like, ma'am is clearly, if ma'am is in the courtroom, she is clearly not uh any sort of a contender. Uh mm, all right, we're just scrolling. You know what? I wonder if I reposted it. Let me see. This seems like an interesting one too. I'm gonna try to get caught up on that one. Melody Ferris. Okay, I just checked Law and Crime and it's still um if you guys are not familiar with this woman, her name is Susan Simpson. She's in the Texas area. Ma'am has been missing for a good period of time now. Let's just say somewhere, I mean, it could be over a week. She's a mother of 4 and ma'am is gone. The husband has been arrested. She's from the San Antonio area. Her name is Susan Simpson. So providing some awareness on that. Oh my God, this was it's not funny, but I got a little key out of it, I'm not gonna lie. Girl, hold on, can you guys see this? Yes, you guys have got to catch this. This is bad. Listen to the reporter, guys.
Stefan, where's Maddie? Did you hurt her? Are you a pedophile? What's on your cell phone? Why aren't you talking to investigators? Where was Maddie last seen? Why aren't you helping her mother and her family? This is a little girl. Help them find Maddie. Where is Maddie? Where is she? What did you do with her? Tell us something.
Let me tell you, she earned her pay that day. Whoever that was, the reporter, she did that. She got every single question that everybody was thinking. Okay. We're not okay. Yeah, YSL, Woody is bringing everybody to church. Okay. Yeah. Let's see. Oh, there's a body. Okay, let's see. I thought I posted that. Okay, there is so NPR podcast reposted it, but um Drake said something about YSL, so we'll see how that goes. Anyway, let's keep going. I don't know. I'll have to find it. Girl, this never gets old right here. Let me see if Sarah's coming in. This does not get old at all, y'all. Girl, them shackles. Mm-mm-mm. I think is that Billy Lane or the guy from the investigative company? Billy Lane, the one who had to scan all of her stuff, the guy with the white tie and black shirt. That's the investigator who was with Cashman. Um, baby, I don't know. You know. Okay, I think okay, here's the walk of shame. Let me go check. I'm over here on Law and Crime. Okay, so I'm watching Law and Crime over on this side, and basically they are saying that Judge Kranick is still with with the other guys. Okay, let's all right. Okay. All right, let's go back over here and we will just wait. I'm gonna go over to Court TV in a second and see what's going on Court TV. I'll close out some of these windows. If you're just now coming in, we are waiting for court to start. Judge Kranick was finalizing some plea deals, some sentencing for some individuals who took plea deals. And so that is the delay. But really and truly, I guess you wouldn't even call it as a court is delayed. Court probably, I'm sure court started on time, but there were other cases ahead of Ms. Boone. Okay. So she has to wait, probably because hers is going to take the majority of the session. So I would just imagine to not have to let other people have to wait to finalize what they have going on. Went ahead and handled that business first, which completely makes sense, right? Okay, I'm back over here. Lucas was a afterthought to George. Well, look, we talk about that a lot over on my other channel, Love Lies and Lace Fronts. There's a lot of women out. Look, men and women. Let's make no mistake. There's a lot of men out here that skedaddle and get involved with their new girlfriend, their new family, their life, working out, their job, and the kid is an afterthought, right? But we talk about mom ish on my other channel. And mom's boyfriend is a thing. Mom's boyfriend is a thing because like we just watched Stefan Starnes do the walk of shame, and that's on some mom's boyfriend, right? Mom put someone over and above herself, responsibilities, her good senses, what's right and what's wrong. There's a lot of women out here that lose themselves the minute that someone is remotely interested in them, and they will give it all for a relationship, unfortunately. And Sarah Boone apparently just, was no longer interested in her husband. She was cheating, she was drinking, she was outside, and her husband got sick of it and they separated. She went and moved in with George while she was still married. And, that was a red flag for George to not be with a married woman, but also should have been a red flag for Sarah. But Sarah was a drunk. Any man who's going to be with a married woman, just like any woman who's going to be with a married man, it's a certain type of individual who ventures into that arena. That's not common. Like that's not something everyone does. That's why people still shun people who do things like that, right? So it's still widely frowned upon that you will do things of that nature. But yeah, she basically put her boyfriend, her needs, her alcohol abuse, her everything over and above the needs of the family, which is the family she created with the ex-husband, i.e. her son, herself as a woman and a mother. And as much as she was drinking when she was with Brian Boone, which I'm sure we're going to hear all about that, it's just the volume of drunken behavior that I think may have increased in her relationship with George Torres, because it seems as though um, that definitely did not get any better. It seems like it got absolutely fundamentally worse. And clearly, because I don't know if Brian Boone was a drinker at all, but probably not to the extent that his wife, people refer to her as a drunk. He referred to her and George as alcoholics. um it interfered. It very much was an interference interrupter. And he opted out of the relationship. He said he got tired of it. She would bring people home, all of the things. And but basically he said she became an alcoholic after she had Lucas. So it could have been I don't know, I'm not trying to come here with a bunch of excuses for her. But at the end of the day, Brian said her alcoholism started after she had the son, and maybe she dipped into some sort of postpartum and used alcohol to um, medicate herself, but it could have possibly exacerbated what we know was already an issue. Guys, it's getting started. Oh my God. Okay, guys. I'm gonna go on mute as soon as they get started. So we're looking at the clock right now, and yes, it is 10:03. Okay. Girl. Yes, that shackle shuffle. Okay, they're pulling back the camera. It's getting ready to get started. Thank you, God. Thank you that there's no more Zoom, because that Zoom situation was a problem. Okay. Zoom was definitely a problem. It's like, why am I being quiet? Okay. Ooh, ooh. Girl. Oh, she is. Sarah takes me right back to when I was in Catholic school. These outfits, this girl, you should have kept your good white blouse for another day. Oh, did you see the jury consultant say to her, "You look nice"? She mouthed to her, "You look nice." Mm. The white girl, you should have saved that white blouse. I think she feels like this is her time to shine. I'm on stage. Sis, it's not going to help you. They are going to drag you, ma'am. And they don't even have to, you can't be mad because there's too much evidence, to quote Mr. Uh, uh, Deputy DA, or one of the DAs in Fulton County, Mr. Will Wooten. You cannot be mad because there is too much evidence. Okay. Can't be mad. Hey, real nurse Jackie, you got here right on time, sis. Ma'am just came in and was released of her shackles. Okay, there's no sound right now. There's Mr. Henderson over there to the left. Okay. There's Mr. Henderson. It's like, y'all ready? Portia. I'm going to put myself on mute as soon as we get things popping. Portia said good morning to Bougie Gang. Good morning, everybody. Mommy's making me be quiet. Yes, I am. Oh, can you believe? Oh my God. I feel like I learned about this case in like 2021, 2022. Right. I didn't hear about it like right after it happened, but it's like, my God, it seems like this has been forever. Portia, Bible Lady said good morning. Portia, Bougie Gang says good morning. Chocolate is her new. Hold on. Chocolate is her new love. Who is Chocolate? You took Mr. Henderson? Girl. India. Good morning. Good morning, Bougie Gang. It's a Bougie Gang roll call this morning. Good morning. Good morning. Good morning, everybody. Sarah Boone is wearing her white shirt. She has her hair swooped back. She's probably asking for a drink of, Sarah's asking for something. Okay. Glass half full said, Portia. Good morning, Bougie Gang. All of you guys who are just now getting here, you are here right on time. Okay. We had a solid hour of chit chat commentary, and we talked about some legal tea, and we went down the Gossip Streets of X. And now we're getting ready to get into this pre-trial, final pre-trial motions. And we're going to get this thing popping. Okay. Sarah came in. She was in shackles. And the lady with the blonde hair, I think she is the jury consultant. She mouthed to Sarah, "You look nice." Okay. She said, "You look nice." Yeah, I want to mess with this as little as possible. So we're just going to let this thing. Girl, I might need to. Do they swear her in every day? I wonder. She is comical. Sis is like a parody of herself, if that makes any sense. Good morning, good morning, good morning, guys. If you're new here, welcome. Take a minute to subscribe to this channel, and we will be covering live the Sarah Boone trial. Oh my God. And also take a minute to thumbs up this live. I wish they would hurry up and put the sound on. I feel like we're like, I'm going to check on Court TV, see what's going on. Okay, maybe Judge is getting ready to hit the volume. They know the world is watching. Okay. She's going to talk to. She's going to. Why do you keep calling him Chocolate Drop? Mr. Henderson probably has a wife of 30 years, probably backing out her 550 GLE or maybe even her Rolls Royce right now. God only knows what his you know what I'm saying? He's trying to finalize wedding payments for his kids. Okay. Sir looks like he has lots of responsibility. He is not trying to sit up there and let Sarah bend his ear. He's trying to help this lady so this doesn't look as bad as it's going to look. Oh God, she got some water. He bought her 2 cups of water. Don't ask for nothing else. Okay. Okay, here we go.
William J. for the state. James Owens on behalf of Sarah Boone.
Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified files filed October 15th, and then the defendant's amended response to same, also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Y'all, it's the voracious typing for me, okay?
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Kopsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes in as one for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as states C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim in anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes is nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we're asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
I love this for Sarah. How is it that he's going to get up and say, I'm confused?
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step one under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like, if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told in outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, You cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made, or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog has bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, could I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th ECA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning?
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in the
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe the state witnesses here, we would like to
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Not from the state. She's allowed to be here to watch. I understand, but I want to know whether she's going to testify. I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she had recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases, I cited the Smith v. State case, the ODEH v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, Well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about.
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree.
Okay, well, the Jackson case speaks for itself and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion as under the Bush case cited by the state. Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
You have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every time.
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate glass
I have to
window.
look at the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be, some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident. I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment. We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the fifth amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed. We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor. Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach this for a second?
He's probably getting ready to be like, look, maybe they just need to, you see Kelsey Copsell, okay, sitting over there. 53 people. So then now they have to narrow it. So they went through 150 to ask, like, are you able? I mean, you could have a single mom who has kid get out of school at 3:00, a single parent, let's just say, who has duties. You could have a full-time caregiver. You can have someone whose job is absolutely like an essential worker. So let's say a surgeon with a very busy schedule, different from, let's just say, a general practitioner who's got backup at his office, his or her office. They'll weigh and measure the availability as it pertains to like essential, absolutely essential. So the 150 has been whittled down to 53. Okay. So just imagine you have to go through 150 to get to 53, right? Now you have 53, and now we're going to get down to, we're selecting the jury from the qualified jury pool. You have a jury pool, now you have a qualified jury pool, and then from now we're going to get the jury, okay? That's why they need 53. Someone tested positive for Rona, someone else is feeling auntie coming to town, and now they're going to have a conversation about the logistics of having everybody assemble, right? I would imagine they should have gotten maintenance into the 20, whatever that room is, and they should have had maintenance sanitize and wipe down chairs. Just try to ask everyone to be as mindful as possible to not touch anything, kind of keep your hands to yourself, and maybe give out masks. I don't know. Girl, I don't know. But yes, the 6-foot rule, since it is cold and flu season right now, probably would be a good idea. To keep your distance, don't touch anything, keep your hands to yourself, have security, open doors. So really,
All right,
like,
going to take a 15-minute recess
okay,
to address jury selection
okay, they're taking a 15-minute recess.
location this afternoon. and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense?
Portia said, bring him on.
Correct. That is correct. I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Okay, are we going to the seal or are we going to the clock? There's Kelsey. Sarah, sit still. Don't move. I would be like, excuse me, can I have a potty break? Can I have excuse me? May I please go to the bathroom, please? You know how Sarah talks. May I please have a bathroom break, please? Okay. All right. So jury pool 150, qualified jurors. Okay. They had a couple of language issues. They had people who are obviously eligible, who are citizens eligible to vote. Because if you did not know, they pick juries from registered voters. Okay. So they had a jury pool of 150. They had 3 different sessions of 50. Of that pool of 150, they got down to qualified. There's not going to be any sort of an issue with understanding the evidence presented. They had some language issues yesterday. They had people who were not proficient enough in English to be able to listen to all of this testimony and to be able to render an opinion. And so they were disqualified. There were people who had issues with the time, maybe because of care issues, whether they're a caregiver, they're a full-time parent, whatever the case might be. They may have some sort of essential worker type job where they cannot be dismissed from their work, right? Or they hold a strong opinion regarding the case. They know about the case. They have an opinion about the case. They may have been a victim of domestic violence. I don't know if they got that deep with it yet. I think that's where they're going today with the 53. For second degree murder, you need a 6-panel jury. And they want to have backup because this is a 3-week trial. So they want to have enough in the event they have fall off. Again, it's cold and flu season. We already have somebody who's out for Auntie Rona. Okay. So who has finished their second cup of coffee? Okay. Can you drop a 2 in the chat if you were on coffee number 2? After I finish this, I'm going to need to go and, after this, I'm sure it's going to be break time. You finished yours, Candy? Okay, I'm into mine. I just made a cup of coffee. If you guys have not tried the Cafe Bustelo unsweetened cold brew, it's good. Okay, it's good. Now, I haven't gotten into that. I kind of drink iced coffees on the weekends sometimes. If I have a really good cup of coffee, I might reserve it and then pour it over ice and make it into an iced coffee later. But I'm not a huge like daily iced coffee, and I'm not usually a second cupper. Sometimes we'll have second cup with my husband in the evening if it's one of those days. But it's one of those mornings today. So when we finish here, I will come back live on some, I don't know, YouTube Street stuff we talk about. Probably some Nesto because I dropped that video earlier. We might do a little bit of Nesto. We'll definitely talk Brandon Dillard. I had some information update on Stefan Stearns. So as far as Atlanta's concerned, I have an update on Christina Peterson and her crazy behind. The former judge, Christina Peterson. I have some information we talked about earlier regarding Christian Walden, wannabe gold. I have a update on Brandon, not a dentist, veneer specialist Dillard. And I'm going to just summarize Miss Carmen Bailey, who got herself into some trouble with Mr. Marquavius Huey on the YSL trial. One of those guards who was giving extra favor to a prisoner who happens to be on YSL. Okay, on the YSL shit show situation. Okay. All right. Did you ever cover an Arab guy trial, Bougie? Did you ever cover this Arab guy's trial? No. I'm not sure what that's about. I'm going to just say no, even though I don't have enough information, but I'm going to probably say no. This Arab guy's trial. Who's the Arab guy? The lemon protein, is it a clear drink? I mean, there are some protein drinks that are not milky. Do you like coffee? Um there is Chike, CHIK, CHI, is it CHICK? Chike protein. They have a yummy mocha protein is clear, girl. You know what? Sometimes you got to just take one for the team. If you got to handle that protein shake business, get some ice, put it in a cup, and just think positive that the result is far more important than the taste. And I'm gonna talk to you. I'm gonna just say it as someone who has, sis ain't skinny over here. Okay, let me tell you. Sometimes it's the taste that puts you in the situation that where this is something that must be done, because I drink protein shakes too. Sometimes I battle with it. Like, I probably should have had one this morning and I did not. So I'm going to take one for you today, Sanders RN. I will drink a Premier Protein for as a meal replacement this afternoon, just to be in solidarity with you, sis. Sometimes you just got to take one for the team. Okay. All right. Just put some ice and keep it pushing. You know what I'm saying? Just get a straw. If you can't use a straw, just sip it down, put some ice in it, and just, there's also some stuff. I have to give you the name. There are some 0-calorie flavor type packets that you can use if you need to. She says she doesn't like the milky taste though. So if she doesn't like the milky taste, she might not like almond milk either. Sometimes you got to just take it. Just imagine, take that. Did you guys watch Soft White Underbelly and the girl who was at the freak off party? That's another thing we're gonna have to do on Saturday. Okay. She showed her us some pictures of when she was in the photo booth. Girl, I totally believe everything she said. I do. When she pulled up the photo booth camera strips, I mean, we know that was a thing at his parties, right? And when she said Young Miami, yes, we must discuss. We must discuss. We'll do that over on OSIP. Why not, right? That's going to have to be, yes. And she had pictures. She did. She was quite credible. She was very much giving, I believe you, sis. I have protein and reds. I don't do. Yeah, I'm like if you don't do regular milk, unless it's with cereal, okay? Milk for cereal. Milk for cereal. Sis, put some ice in it. Squeeze, maybe get a piece of fruit, some fruits that you like or something. If it's a lemon flavor drink that's a protein drink, get maybe add put it in the blender. This would turn it to a smoothie, put something like an apple in it and girl, handle that business. Don't think about it. You know what I mean? Because the end results are far better than, 3 to 5 minutes of unpleasant tasting something. Sometimes you got to just, you know, like I said, take one for the team. You can hit me offline if you want to. Send me a note on Instagram. We talk about it. Yeah. Put some apple juice with it. I would drop like a really yummy apple or something. Oh, I love yogurt. Do you like yogurt? I had to scarf down ratio yogurt this morning. And the yogurt, don't forget, like if you like apples, cut yourself a nice slice of apple and dip it in your yogurt. Use your yogurt as a dip. Don't, you know what I mean? If you struggle with yogurt, dip a fruit in it that you like, not to be excessive with it. Or some people like avocado. Um, I don't I like to eat avocado as a savory. I don't really get with it in smoothies and things like that, but I hear some people do like it and it's good. Girl, crushed ice, you can drink anything on some crushed ice. Crushed ice is my boo. Crushed ice is boo and bay for me. I love crushed ice. What about eating foods that are high in protein? She might be on a situation where she's got to drink her protein, right? I don't know. You know what I mean? Like she'd mentioned she had to drink some protein. And I know ideally, eating your protein is better. But maybe there's a situation where sis needs to drink it right now or soft foods. I'm just guessing there might be a reason. Girl, crushed ice is everything. Okay, well, good luck with that, boo boo. Best of luck. Yes, ma'am. Yes, ma'am. Best of luck with that situation. Okay. And you may as well because, yeah, hit me up on Instagram. We'll talk. Protein is always, never, I don't want to say you never have too much protein, but by the time you get to eat too much, um, that's I don't know. I love shrimp, lobster, all of that is super high protein. Um, but yeah, I'm since we've talked so much about protein, I am going to do a Premier protein, or I should have done a mocha protein drink from Chike. Chike is really good. I like that. Um, and but yeah, I'm gonna do one for lunch. Girl, you know how much I love milk. I don't not an everyday milk drinker, but I Fairlife is my favorite. I used to like Horizon. I used to get that DHEA when Farah was still like up until she was about 2, and then we switched to Fairlife. Fairlife is so that ultra filtered milk. If you're ever struggling to just get a little bit of extra protein in, that ultra filter, just 8 ounces. I mean, it's so good. It just tastes so refreshing. The 2% is so refreshing. Yesterday, I was like, Farrah, can you give me a cup of milk? And if I'm really feeling jazzy with it, then I might do some milk over crushed ice. Okay. Love that too. Sending me some pixie dust. Oh, you're sending her pixie dust. Yes, 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 yes. Well wishes, boo boo. I just got the vibe. When you said it, I got the vibe. So we get it, hun. Yeah, my husband likes almond milk. Farrah likes it too. Farrah's like, I think Farrah likes it as a treat. She's a milk drinker too, but she likes it's okay. It's just not my preference. It's kind of a preference thing for me. I will drink it. It's kind of like a novelty for me. It's not like my go-to. Fairlife. Fairlife 2% is my jam. Absolutely, sis. Okay, so they went on a 15-minute break. I would hope that they have cleaned and sanitized the room that they were discussing. Let's go on Twitter and see let's go on X, formerly Twitter, see what's what. Let's take a dip over to X. Okay. Let's see what's going on. I'm not going to flip the screen. I'm going to go X by myself. Let's see. Two packs of juice, 5 peppermint, returned to court today to argue some motions, including adjusting her meals to keep her energy level, the long-awaited opening statements. Okay. Okay, hold on a second, guys. I'm keeping an eye on the court, so don't worry.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning. And then, of course, she's brought up around 9. And then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stop allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart. To allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not.
It was just can I have 2 juice packs, 2 bags of chips, some candy. She gets a peanut butter and jelly in the basement. Girl, if you don't get your behind,
she says she gets like today.
And a
she's feeling tired
Pop-Tart.
and lethargic, and so she feels like those items during a break that she could have something like that to keep her energy level.
Have a peanut butter jelly sandwich
I'm
in the
asking
basement.
for the court's permission that she be allowed to do that.
State, any response?
Not the state attorney's office and any of the parties involved.
Okay. I will,
The state said what is it? IDGAF. Okay. The state said IDGAF times 10.
speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what.
They are not going to deprive her of food, no matter what, no matter how this little kiki we're getting right now. She's asking for food. They illustrated that there's going to be a long time period between eating, and these lawyers are going to go and have meals. We'll finish this up when we come back. Judge is coming back to his seat. Okay. We'll finish up that little tea in a minute.
2603 State of Florida versus Sarah Boone. State.
Get her a Lunchable. Can Miss Boone have a junk food bag, please? I moved for a bag of junk food, please.
Ms. Boone is still seated at council's table wearing the same gray suit and white blouse from this morning. Can y'all approach?
I moved to get Miss Boone some food and refreshments, but we will only do healthy snacks. We will do 2 apples, a pear, a Premier Protein, since we've talked about protein, and we will give her a good turkey sandwich, okay, on a nice 12-grain bread with mustard, no mayo, and a tomato slice, okay? That's what would be in the Bougie Gang lunch bag. We're going to have cucumber slices, apples, a turkey sandwich, no mayo, a Premier Protein, 2 water bottles, and 2 packets of Crystal Light. That's it. That's all. No chips, no candies, no ho-hos. You getting a healthy snack. Okay, ma'am? Carrot sticks. Okay? Sis. Ma'am, you got to eat a little bit better over there. Can you believe that? Girl, I would have been asking them to order me some Panera. Can I get some broccoli and cheese soup? Can I get a baguette with turkey, avocado, and a little bit of bacon, please? And I will take a nice unsweetened tea with lemonade. Can I get an Arnold Palmer light on the sweet, please? And I'll take one of those good apples. If it's Pink Lady, the better. Okay, Pink Lady or Macintosh. Thank you. And 2 peppermints. A little peppermint, please. Let me tell you something Farrah did. It was so cute. Farrah, we went to the store yesterday. I didn't even know what she was buying, but she bought a bag of Jolly Ranchers, which took me right back again to Catholic school because I used to have a few in my pocket, in my blazer. And she gave me the bag this morning. She's like, "Oh, Mom, you can take a few. They're so good. Blue is my favorite." And I was already dumping the bag out because I was like, "Farrah, I'm not gonna lie, my favorite is the green. Like, that's my all-time favorite. I used to sneak those in chemistry class when I was in high school." And she's like, "Well, you can take as many as you want." And I'm thinking to myself, well, I did pay for it yesterday, but that was so sweet. She shared her Jolly Ranchers with me. Apple is bae, okay? But she hit me up to the blue, which I don't know that I've even ever eaten the blues. But she gave me 2 blue and 2 green. And then she stuffed a couple in her pockets. I was like, oh, to be in elementary school, well, middle school again. To be a 13-year-old again. If I knew then what I knew now. Fun times. The cherry. No mayo, that's cruel. Okay, she can get a little mayo. I'm just saying, can they get the lady a healthy girl? They said they serve peanut butter and jelly in the basement, okay? That's what Farah told me. I've got them sitting on my desk right now. Girl, we're gonna go back and watch that little section, that little TT that Mr. Owens spilt about what is served for lunch down in the basement. How can you eat with shackles and handcuffs? Girl, you know what? Let me talk to you about bread. Just stop buying it. Um, just stop buying it. At a certain point, if you kind of get to the point where it's like, oh yeah, I didn't so I love Jersey Mike's, right? I did start back getting a sub and a tub. When I was more mindful, I still got my number 8, but I would get it in a bowl. So, could one of you guys were like, "Oh yeah, I got a sub and a tub." And someone said, "What's the difference with that and a salad?" And I'm like, "It's a salad. They just call it sub and a tub. It's Jersey Mike's, okay?" Anyway, but it's so good. It's so good. You don't even need salad dressing. If you get it Mike's way and they put the salt, pepper, oregano, oil and vinegar, it's perfect just the way it is.
All right,
Just
court's going to step out for
okay,
one
guys.
second, and
Oh.
then you can
Girl, drama. The court is going to
email
step
that
out.
exhibit list to Madam Clerk, and then we can go from there. Thank you.
Girl, it's drama. Okay. Did he forget to turn off? May I have some water, please? Please, may I have some water, please? Sarah, don't, girl. Please, may I have some water, please? The judge said, well, do you need anything else? This was on Monday. She says, please, may I have some water, please? I've never been a bread fan. Well, that's why we see you in that mirror, in that selfie, sis. We see what's going on there. Girl, I love bread and bread hates my guts, okay? Bread does not like me, but that's okay. I've learned how to trick bread. It's like, bread, you're not coming home with me. I can walk right past the bread aisle and not even think anything of it. Now, I do like bread. I'm not going to lie, but I purposely I don't like, oh yeah, we need bread. I don't even try to remember to buy it because I know Farah, like she deserves to have bread. So she can have bread in the house and stuff like that, but it's not like our mainstay. If there's no bread, it's not a big deal. You know what I mean? But I try to make sure to keep a little bit of bread because sometimes we will have a sandwich or whatever. You know what I'm saying? But I try to limit it. And so if I buy bread, and maybe I'm doing like a big shop for the next 2 weeks, that's the bread that's lasting for the next 2 weeks. And if it's eaten in a weekend, well, we just won't have any bread because mom's not going back to the store. That's it. That's all. I just think for me, it's better to not have it in the house rather than to like make a bad decision. Bread, buy bread. Buy bread. Let me tell you, you know what I could really have an argument with is like the baguettes because I love French bread or Italian bread, and that would be what I would bring home. But the good thing with that though is by the next day, it's typically not amazing anymore. Sometimes I will like slice it, butter it, and put it in the freezer for like when we make spaghetti or something like that. But yeah. Yeah. Just limiting it as we are approaching Bougie Gang lunch hour. Okay, let's go back to Twitter for a second. Okay. Okay, let's go back to Twitter for a second and finish up the information. I don't even know if we have 2 minutes. Any of you guys just coming in?
Judge, my client tells me that she,
Look, if I were Judge Cranick, I'm joking here. If you don't sit your ass down, Mr.
they
Owens,
wake her up at 2:30 in the morning, and then she's kept in a
who is this man scratching his
holding
goatee?
cell until she's brought to court here at 6:30 in the morning. And then, of course, she's brought up around 9. And then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stop allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
State, any response?
Not the State Attorney's Office and any of the parties involved.
Okay. I will speak to the captain at the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow. All right. Anything else?
Not that he said stored downstairs. I'm like, ooh, wow. What a bad position to be in. I mean, it's a bad position. I mean, breaking the law, if it's not abundantly obvious and clear, I'm sure for a lot of us, this doesn't even have to be told. This is a story that doesn't even have to be told in terms of the lack of interest in even venturing into that realm. But you really relinquish your rights. I mean, you have relinquished because you know what I'm saying? Like, because you are alleged to have broken the law. I mean, it really is a privilege to be out on some bond, because if you are in the custody of the state, baby, you are stored, housed, whatever you want to call it. It is what it is. Mm-mm-mm. Mm-mm-mm-mm-mm. Never. Whew. I'm just refreshing. We're still on the medallion. It's like it's 30 seconds behind for some reason. Are we live? Okay, we're on the red. Okay. I'm listening. I am listening to the right part. Inmates are considered part. Yeah. State property. I mean, she's not state property yet, but she is in the custody of, she hasn't been convicted yet. But ooh. Now, if she has 2 lunch bags, then she's got snacks. Girl, Bread is my friend, but I'm Bread's friend because I love Bread, but Bread does not love me. Okay. What has Pop-Tarts to do with anything? Kellogg said, how did we get dragged into this Sarah Boone business? Wait, we need to know once again. Hold on a second. Let me just He said, "Can we have 2 juice packs?" 2 juice packs. Can someone write this down? 2 juice packs. 5 peppermints. 2 bags of chips. A bag of candy. And a bag of cookies or a Pop-Tart. Sis, baby, honey, you're over 40 now. That is my 13-year-old wouldn't even ask for that. I guess I thought about the Jolly Rancher she got yesterday for that reason. Baby, come on now. Okay? Come on now. Stop with the shenanigans, okay?
All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, you can get appearances.
William J. for the state.
Defense. All right, thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been provided by Madam Clerk defendant's 5th amended reciprocal discovery exhibit list. I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, I did want to say that the notice of provision of defendant's 5th amendment exhibit list was e-filed on October 3rd. The 5th list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir. Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there. And also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Is this going to be considered a separate hearing for the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline, count up as 80 photographs and videos. Attachments and rebuttal, count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names, providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example, on page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos. 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m. 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is Again, 108 pages. It starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there was problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of the child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we set. We believe we'll give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598 from the Second District Court of Appeal, decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal, decided in 2018. Gale, G-A-Y-L-E versus State, 216 Southern 3rd, 656, 4th District Court of Appeal case as well in 2017. The basics of these three cases are just the very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. but I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision, was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay, and it's not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of, or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity, that these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It
Correct.
is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is at that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to. Sounds like it covers the suitcase video to me. All means all.
The suitcase video is listed in the things that we don't object to.
I don't know that. I have image _ 0954. I don't know what that is. Image _ 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
Part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint, for the ones that we didn't list the number and I didn't give detail as to, like, IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, that I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
I wonder why they can't just say, look, I'm going to double check the file. And if there's any pictures of Lucas, we will omit them. If they are material to the presentation, then there may be a couple of pictures, but for privacy's sake, middle school sake, the child is not relevant to the case sake, outside of mom being a failed mom, unfortunately, allegedly, we will double check everything. Okay. So here comes, okay, so sis probably went through all of the pictures. So if they found a picture, okay, we'll take that one out. I mean, my God. Right. 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, cookies, and a Pop-Tart. Okay.
Okay, I see 2 images. I couldn't recognize it as reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but
Okay, so it's not a picture of the child, it's a reflection of.
no objection to removing those 2. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
Well,
I'm sorry,
it's an
Judge.
extraordinary file name, but I'm going to remove those 2 exhibits that
I'll take care of that issue for you, sir.
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much. Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's 5th amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Whew. Okay, Mr. Henderson tries to, you remember, you guys, okay, remember how like Matlock and Columbo used to try to play like they didn't know what they were talking about, or they would try to come in like super unassuming and almost kind of like, oh, well, oh, is that there? Oh, excuse me. I didn't know that would happen. You know, kind of playing in everybody's face, okay? They said, "Sarah, sit your behind down." Okay? And Sarah couldn't help but look at the camera. Okay, Sarah. Sarah not sitting in your seat, okay? Sarah. Miss 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, some cookies and a Pop-Tart, ma'am. Okay? Sis said, "Do not play." So she puts the belt on. It appears that she loops the handcuff into the shackle and then wraps the shackle around. Oh, wow. It's like a double thing. Ma'am said, "Okay, now here you go." Okay. It's one chain shackle, and we'll look at that one more time. Okay, it's a 1 chain shackle, and they take it and wrap it around for the 2 times. They take the handcuff and attach it to the shackle and wrap that thing around for the 2 times, and ma'am is escorted out. Look at Mr. Henderson, aka Ving Rhames. He is coming through to disrupt. He's coming through to dismantle facts. Well, what does the pictures have to do with anything? We want to object to all video and photography and photos. Well, I don't know where they came from. We don't know about the authenticity. Sis is like, "Look, don't try to disrupt me while I'm doing the very important." Here she goes. Let's cuff her up. It's 1 turn, and then she'll do another turn. Okay, hold on a second, guys. Okay, voicemail. Okay. All right. So yeah. Okay, Sarah. Sarah making lemonade. Okay. Okay, Miss girl. Miss 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, cookies, or a Pop-Tart. What adult woman at 47 years old wants 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, cookies, and a Pop-Tart for a whole day of food? Not, my head would hurt so bad. Not to mention, even if I sat there and got through all of that, I would still be hungry. That is literally the epitome of an empty calorie situation. That is nothing that is nothing but sugar. Nothing but sugar. Are you kidding me? I would be cuckoo. They'd probably have to rush me down to the nurse's office because my blood sugar would be like damn 405. Okay, girl, a mess. Can I have 2 juice packs, 5 peppermints, 2 bags of chips? What? It's giving, sis. You have literally been institutionalized for like a long time. You don't even know what a proper lunch is for a woman your age. Like, sis, no. Okay. That's Anywho, interesting stuff. This morning did not disappoint for me. I hope you guys enjoyed this. This was not disappointing at all. What's up with the chain? She's in shackles. She's in jail. She's in jail on 2nd-degree murder and she gets no bail. And yes, it's called, what's her number? I don't even know. It's called under the custody of the sheriff of Orange County. Yeah, she's in shackles. We've seen Nesto in shackles. That's what it is. That's what it's called. It's called felonies. It's called felonious and no bail. Okay. It's called in jail without the bail. Okay. She didn't get bail. She complained because she didn't get bail. You did not get bail because you're there for 2nd-degree murder, sis. That doesn't come with bail. Okay. Okay. Our sis over there on Court TV got a bag of candy, some Pop-Tarts. I guess she got some chips out. Julie at Court TV got the snacks out. Okay. Sarah better leave that stuff alone. Girl, someone said Dr. Pepper and cigarettes. Okay. A mess. Let's see. Oh, did she do it right here? Hold on.
Pop-Tarts. Check. Candy. Check. Chips. Check. Juice packs. Check. Peppermints. Check. Oh, and a bag of cookies, just in case the Pop-Tarts don't work out. Check. These things are what defendant Sarah Boone wants to snack on during her homicide trial. That's right, she's requesting a mix of salty and sweet treats to enjoy while the state is going to be presenting evidence that she murdered her boyfriend.
Okay.
My friends, the fact that this woman could even think about food at a time like this is stunning to me. And no, she doesn't have low blood sugar, if you're wondering. And yes, the jail does provide meals for her to take with her. What she does seem to have is the diet of a 6-year-old. I was talking to my colleague about these things that her 6-year-old daughter likes to enjoy packed in her lunch, right? But, even 6-year-old kids seem to have a lot more restraint than defendant Sarah Boone. Because they know they don't get to snack all day long during kindergarten, right? They know they're going to be fed snacks at the designated snack time. I'll tell you what else 6-year-olds understand better than Sarah Boone. They understand the golden rule. that you treat others the way that you want to be treated. And I bet if we asked any 6-year-old if what Sarah Boone did, leaving George Torres in the suitcase, was okay, they would undoubtedly say no.
Absolutely.
Because
I think even that's such a amazing point. Even a child, and we're talking about like upon entry, let's talk kindergarten, first grade, would know that it's not a good idea to do what she did, on top of the fact like to hurt a friend. Because when we learn not to hurt a friend or someone we love and care about very early, right? No hitting, no biting, no scratching. You don't want to hurt a friend, right? Unbelievable. Okay, let's talk about this really quick. And then I'm gonna let you guys go because I'm gonna go live again, probably in like 30, 45 minutes and take a little, I'm gonna get myself together a little bit more. Um, the phone conversations that she was having with George's brother. Now, I'm assuming, I don't know if that was Juan, was that Pharrell? Pharrell's the one who beat him up, I believe, if I'm not mistaken. Juan was the one that they talked to the night that, or the night that George got into the suitcase, never to come out alive. And they were arguing and fussing. Sarah and George were, and then George got off the phone after he was talking to his brother and his niece and nephews, right? What was the dialogue about? I'll get rid of him, or whatever that was. I don't know, but it seems like the prosecution has some dun 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 type evidence. I don't know. Very interesting. So let's do this. We'll revisit this maybe a little bit later for like a half an hour tonight. Let's let the Madam Secretary, court reporter, and the clerk get the notes from today typed up, because they're going to post all of the decisions. I'll check the docket and see when it gets posted, because I'm sure they'll have the notes, they'll have the decisions, and then we can kind of summarize everything that happened today, with the notes and the rulings, and just do like a kind of like a little quick, this is the wrap up of what what happened today. But anyway, you guys take care. This was fun. I enjoyed it. They're getting back to jury selection. We'll probably meet again tomorrow. If we don't do it tonight, we'll do it tomorrow. We'll talk about what happened today, because I don't know that we're coming back for any more hearings before everything gets started. But you never know. You never know with this. Okay. They could, maybe we'll be back tomorrow with some hearing. I don't know, but I think they heard everything that was on the to-do list. And either I'll put something on the community wall. One way or the other, we'll talk about it. Either it's going to be this evening quickly or tomorrow. But I'm going to take a quick little break, and I'm going to be back, and we'll get on pivot to something else. You guys have a great day. Thank you to everybody who was here. If you're new here, welcome. Otherwise, you guys have a wonderful afternoon, and I will see you guys later on. Bye, guys.